Hello and welcome again to everyone who's just joined us. Before we begin in earnest, I'd like to acknowledge the traditional owners of the land on which this meeting is taking place. And I'm on Fitzgerald country, and I'd like to pay my respects to the people of the Rio Nation. And I'd like to pay my respects to elders past, present, and emerging, and to acknowledge that sovereignty is never ceded. So thank you again for joining us tonight. For those who I haven't spoken to before, my name is Vanessa. I'm joined by my lovely colleagues Emma and James tonight. For those who have come to our previous webinars, you'll know that they're split into two distinct sections. So the first half is the new half in every webinar, and you'll know that we have a special guest speaker during the first half, and tonight it'll be James, who will give us a little deep dive into the First Nations engagement work that we're doing here at ACCR. And then in the second half, Emma will go into what it means to be a shareholder in our community and how you can get involved. And so for those of you who are new to ACCR, we work across a range of ESG issues, and the two big things we do is research and shareholder advocacy. So hopefully you'll be able to get a little bit of a taste of both those things in tonight's webinar. But before I hand over to James, just a little bit of housekeeping. This webinar is being recorded. And so for those of you who would like to see it afterwards, we can send you a link to that. And the second thing is there is a Q&A chat down below. So if you have any questions, please type them in there and we'll get to them. If not during the presentations, we have dedicated Q&A times at the end of the first and the second half. So without further ado, I'm going to hand over to James now to kick us off.
Thank you, Vanessa. Thanks, Emma. Hello, everyone. Good evening. Thanks for having me. My name is James Fitzgerald. I'm the Corporate Counsel and First Nations Engagement Lead at ACCR. I'm coming to you tonight from Bidjigal country in eastern Sydney. I'd like to acknowledge those traditional owners. First of all, I should say a quick bit about myself. I'm a lawyer by training, have started in commercial law, drifted into native title soon after the Mabo decision, excited by the prospects of that particular injustice being resolved, and ended up staying in the area for almost 25 years. I came to ACCR at the end of 2018, having done what I thought was the extent of the work I was going to do in the native title space, having worked overseas for consulting to a few mining companies for a number of years. But unfortunately, the Juukan Gorge cave destruction has brought it all back to us. So part of what I'll tell you is about what we do and the journey about how we got to be doing it. First of all, what do we do in this space? Well, I mean, the other thing I should mention is I work part-time. I am the only person doing First Nations work at ACCR at the moment. It's a limited engagement, but we've had some fairly high impact in the recent years. The way we work, we act in cooperation with First Nations peak organisations around Australia. It depends upon the location of the work, the location of the issues, and there are certainly no shortage of organisations in each state and territory. But principally at the moment, we're working with the National Native Title Council, which has a mandate to represent, it's the peak body of native title in Australia, both for land councils and for so-called prescribed body corporates, the unitary native title group organisations, and also at the moment with the West Australian Aboriginal Heritage Action Alliance. And I'll talk more about that in a little while. That alliance is deeply involved in trying to improve cultural heritage standards in Western Australia, particularly in the wake of the Juukan Gorge Caves destruction and the reports of the Juukan Gorge Commonwealth inquiry. Principally, when I say we act in cooperation with, we see our role at the moment primarily as being a conduit between First Nations peak organisations and investors in ASX-listed companies, and principally in matters that should be of interest to both. There's certainly agendas that extend beyond for both shareholders and Aboriginal groups, especially affected by mining. But there is also a significant overlap. And this is a relatively new engagement, as I understand it, Australia-wide. Certainly there have been Aboriginal groups from time to time making their case on one issue or another at ASX-listed company annual general meetings. But I suppose the big breakthrough of the last 24 months, even the last 12 months, has been the extent of the ongoing engagement between Aboriginal people particularly affected by mining and the shareholders of those companies. I'm going to give you 3 examples of the work that we've been doing, and it also shows a kind of an evolution of that work in the period since 2019. When I arrived, ACCR was working with native title holders in the Northern Territory in relation to their concerns about the fracking plans for particularly the Beetaloo Basin, the Beetaloo Sub-Basin, a massive area that extends north to south from Katherine to Elliot down the Sturt Highway, and then to wide area either side, mainly pastoral lease country. And so the Aboriginal Land Rights Act, which would provide them with a veto in other circumstances, doesn't apply because of the existence of the pastoral leases. Instead, these people have had their native title recognised, but it's non-exclusive native title. They share that land with the pastoralists, and their native title rights afford relatively low levels of ability to have a real say in industrial activities on that country. In 2019, and then again in 2020, we had significant groups of native title holders from the Beetaloo Sub-Basin come down to attend the Origin Energy AGM in Sydney and voice their concerns directly to shareholders and members of the board. The circumstances of the Beetaloo Basin, that it's one of the main targets of the Morrison government's so-called gas-led recovery. The problem up there is, I don't know if people are so much concerned about bigger issues of global warming. I'm sure that's a part of their concern. But the principal concern of native title holders, as well as, by the way, pastoralists and even the townsfolk of places like Katherine, is that I'm sure many of you have visited the Northern Territory. It's a very hot place. It only rained 2 or 3 months of the year, and for the rest of the year, it's an arid place. For the rest of the year, all life depends on the subterranean waters that are interconnected. A lot of the places have names like, Daily Waters or Somewhere Springs. That's because the settlements exist around these groundwater springs. And there's an enormous amount of concern about the effect of wide-scale industrial fracking in that area and what it may do to even the viability of life if the fracking goes wrong and those interconnected waters are affected. ACCR's response was to translate those concerns into a resolution which would be pertinent to the board, and it was principally, it was a fairly modest ask, asking for the company to conduct an audit of its social licence to operate in the Beetaloo Sub-Basin. On both occasions, the result was relatively disappointing. Less than 12% of shareholders voted in favour of that resolution. The principal reason for that is that the chair and the board of Origin Energy was able to point to their engagement with the Northern Land Council, which purports to represent the native title holders. And their position was, look, we are talking to the right people, and we're told by the Northern Land Council that people are very happy to have us there. We've got good relations with the native title holders affected by our operations, etc., etc. But they were able to rely on the relationship with NLC to simply say, it's not our problem. We're told everything's okay. The subtext to that story is that the NLC has in place arrangements which gives it de facto monopolistic representation rights over native title holders in circumstances where many would like to get out of that arrangement. And around the rest of the country, what we see is that in the years since native title has been determined, the role of the land councils, the native title representative bodies, of which NLC is one, has changed. And in many parts of Australia, native title holders have now got their own representation. Very grateful for the work done by the Land Council in the native title recognition process, but they're moving on. That is not something that the Beetaloo native title holders can do for various technical reasons that I'd be happy to go into if asked. But the upshot of that is that there is a serious discord between the company's assertions and the on-ground reality. And as we go through these slides, I think you'll see this is an ongoing theme, a consistent theme through our work in this area. As a famous Australian historian once said, we suffer in this country from the tyranny of distance. Even though we are one country, the experience of those in remote mining regions is entirely different from the experience of those living their life in a capital city. And I suppose a big part of what we do is trying to bridge that gulf, to live in that void between the cities and these remote places, and to ensure to the extent that we can that decision makers in capital cities, and particularly shareholders, have a better idea of the on-ground realities. Last year's example, when I think of 2020, just about all I think about is Rio Tinto and the Juukan Gorge caves controversy. I'd like to talk a little bit about the circumstances and our role in that. As many of you will remember, it was reported at the end of May 2020, just after Rio Tinto's 2020 AGM, that the company had destroyed some extraordinarily valuable caves, 64,000 years old, with remarkable evidence of early habitation. It wasn't just a PKKP cultural heritage, it was extraordinary world heritage. You may also remember that the immediate response of Rio Tinto was pretty much silence. And when we did hear from Rio Tinto after a couple of weeks, it was a case of sorry, not sorry. The company apologised for hurt to the traditional owners, the Binigura people, PKKP, but at the same time said, look, what we did was legal and, it's not really our problem. At that point, what really concerned me personally, having worked for 10 years in the Pilbara with many of those groups, including the PKKP, in their engagements with mining companies, was that there was every prospect that the story of the destruction of those caves would survive a couple of news cycles and then disappear. Initially, there really was very little response. And it was, as I say, it was only belatedly that the company felt that it even needed to say something about it. I hate to keep tying it back to my own career, but I'd spent some 20 years engaging in negotiations with Rio Tinto on behalf of groups in the Pilbara, North Queensland, other places, and then later consulted the company overseas. But in the course of doing that, became intimately involved with just what an extraordinary effort that company had made since 1995 to break ranks with the mining industry and make itself the exemplar of best practice in this country when it came to Indigenous community relations. And so the destruction of the Juukan Gorge caves and the response of the company, the fairly callous response of the company, was really breathtaking. Now, because the destruction occurred outside the AGM cycle, there was no prospect of using the usual tool of a resolution. I suppose organically, first of all, through just making contact with former senior executives of the company who were deeply distressed by what had occurred, it became clear that we had the potential to elevate awareness of what had occurred and just how profoundly wrong it was, and what a fall from grace that it constituted for Rio Tinto with shareholders, because it was quite clear also that the government, either state or territory, was not going to do anything. The the WA government had rubber stamped the approval for the destruction of the caves, and the Commonwealth was simply lying doggo. They weren't saying a word. So the only, and this is one of the significant things I'd like to convey to you, the only audience that was capable of influencing the situation were Rio Tinto shareholders. With the help of former Rio Tinto executives, including former Vice President Paul Wand, with Professor Glyn Cochrane, who was the architect of the excellent system that Rio Tinto put in place in 1995, responding to Mabo No. 2 and the recognition of native title in Australia, with Professor Marcia Langton, who'd worked closely with the company, and also others like Bruce Harvey, the former Vice President of Community Relations. You know, we started doing webinars. We just simply wanted to assist interested shareholders to understand how mining works in the Pilbara, how far it is from you know, what's in the advertisements and the brochures, and to simply lay the facts out there to see how shareholders felt about it. Subsequently, in June, July, the Commonwealth established an inquiry, the Northern Australian Standing Committee chaired by Senator Warren Entsch. We call it the Juukan inquiry. We assisted First Nations leaders and ex-Rio Tinto executives, you know, in terms of marshalling people to make submissions, to be involved, and to really expose the truth behind what had occurred. And in circumstances, by the way, where Rio Tinto's own board had commissioned its now ex-director, Michael L'Estrange, to produce a report which the committee chair, Warren Entsch, said, quote, beggars belief. So even in the face of the pressure that was being put on, the default position of the company was to simply, well, you know, gild the lily in the hope that most people wouldn't get it. And here again is another one of those themes that I'd like to highlight. All three big Pilbara companies, Rio Tinto, BHP, FMG, their external relations function, their strategy, the communication strategies are premised on average Australians and average investors knowing almost nothing about how mining works. And so our challenge was just to fill that void. And I think we were extremely successful in that. I am enormously admiring of certain shareholder companies for their performance there, for taking it up. And, you know, we saw the result late in 2020 of the resignation of the group CEO. That was John Sebastian Jacques, Iron Ore Chief Chris Salisbury, External Relations Chief Simone Niven, Michael L'Estrange, and the chairman, Simon Thompson, also announced that he's going to retire prematurely before the next AGM. That alone is not a victory, but it certainly cut some of the cancer out of the company. And there have actually since been some significant actions by the company, including the adoption of the Canadian so-called Towards Sustainable Mining initiative for reporting, which will also help to close that gap of knowledge for shareholders who are interested and paying attention. This year, I'm just using examples, the controversy about the protection and management of Aboriginal cultural heritage in Australia has largely moved on to the failure, the inadequacy of the regulatory regime across the country. In December last year, we had the interim report of the Juukan committee, which was, well, it was damning of just about everybody. Nobody escaped criticism for what had occurred. But at the bottom of the observations and recommendations there, the inquiry found that the Western Australian Aboriginal Heritage Act was not fit for purpose. It needed urgent repeal and replacement. And the inquiry made recommendations accordingly. The inquiry also recommended that, given the circumstances and the fact that the PKK people, having been failed by the Western Australian legislation, had attempted to appeal to the Commonwealth Minister to take action under the Commonwealth Aboriginal and Torres Strait Islander Heritage Act, recommended also that that act be repealed and that there be new legislation at the Commonwealth level to act as a safety net where the states, failed in their duty adequately to protect cultural heritage. That will become relevant in a moment. Now, this year, again, at the request of the Aboriginal Heritage Action Alliance of Western Australia and the National Native Title Council, we have filed for Fortescue Metals Group's annual general meeting a resolution that sets out, that refers to the Juukan inquiry recommendations and findings, and that calls on the company, it's a fairly modest ask, simply to support publicly Western Australian First Nation groups' calls on the Western Australian government to pause the enactment of the current Aboriginal Cultural Heritage Bill developed by the ex-minister Ben Wyatt. I am responsible for the typo there. It's Nen Wyatt, that might be his auntie, but Ben was the ex-minister, calling on the company to, and calling on the state to engage in a process of co-design of the new laws with First Nations representatives. So essentially what this resolution is doing is just testing the extent of consistency between the company's rhetoric and its actions. By the way, and I should add, the final report of the Juukan inquiry, which was released earlier this week, supports that First Nations position. We didn't know that when we drafted the resolution a month ago, but in fact, there is a statement, paragraph 4.135 of the final report of the Juukan inquiry, that says, quote, in light of the above issues, they are the concerns raised by Aboriginal people in Western Australia about the Western Australian Cultural Heritage Bill. In light of those issues, the committee encourages West Australian government to review the bill and to make amendments to address these concerns. And particular consideration should be given to accommodating the principles of free, prior and informed consent. Now that term free, prior and informed consent has special meaning because it falls within the United Nations Declaration of the Rights of Indigenous People, to which Australia has been a signatory to since 2007. And another one of the key findings of the committee is that Australia's cultural heritage and native title laws simply don't meet that standard. They don't meet the standards to which Australia has internationally ascribed. We filed this sometime about a month ago. FMG's AGM is on the 9th of November. We've received on the 4th of October FMG's formal response. Essentially, they agree in principle, but not in practice. They say, oh, look, we're prepared to support publicly recommendation 2 of the Juukan inquiry's interim report that says, there needs to be better legislation up to free, prior, informed consent standards, and with much more involvement for Indigenous custodians of cultural heritage. But we don't want to support actual Aboriginal people in their calls on the government to pause the current bill or to renegotiate its terms because we just don't know where this is going to end up. And another proposition they make is that, look, we like the fact that it's the state minister that makes the final decisions about what heritage gets destroyed. So, from my own perspective, I don't think it's a very fair income response. I personally, from all the observations and knowledge I have of the mining industry, particularly in Western Australia, they've spent many years getting to a stage where they have a very significant amount of control over and persuasion over the state's mining laws and policies. And they're not in a big hurry to disturb the status quo too much. I think everybody agrees there must be gestures made following Juukan Gorge, but the current bill being proposed by West Australia, again, under the auspices of Ben Wyatt, who has since left politics to join the board of Rio Tinto and Woodside, that legislation does not meet those standards. And I think rather than listen to me talk about it, the best thing we could do is have a look at a 3-minute video that was made by colleagues at Aboriginal power. And here we'll be hearing from a range of Western Australian mine-affected traditional owners, many of whom are old clients and friends, and about their concerns about the current bill.
When only one person out of this parliament can make the decision on our sacred sites, that's a no-no, that's wrong. We want the right to negotiate what's in that act. The act in its current form is not workable with us.
Unprecedented. We have senior law men and women from right across this state come together united as one with deep, deep concerns about a process that they haven't fully been involved in.
We want the opportunity to be sitting at the table with the government and negotiate the process going forward.
We want protection. The word's not even in the Aboriginal Heritage Act. It's not there, and we do want protection. Our heritage is our land, our water, our trees, animals. We come from the country. We didn't come here in boats. We were here already. That's the definition of heritage, is what have you inherited?
To be able to give the minister absolute power is an absolute disgrace.
We've had enough of being told what we can have, what we can't have, and what we can do, and where we can do it.
People have been consulted for so many times. We are the most consulted people in the country, and we don't want to consult anymore. What we want to do is have the right to sit at a table to negotiate an outcome, not be consulted on a proposal that's been drafted by government and then brought to us at a later stage. We want to have the ability to be able to say no.
Put the minister on notice today to inform him that we are using a formal process to take a complaint to the Committee for the Elimination of Race Discrimination, because we believe that the bill in its current form is not fit for purpose. So we believe that the current format does impact on our human rights, most importantly our rights as Indigenous people to have free, prior and informed consent decision-making. It impacts on our spiritual well-being, and it impacts on the well-being of the nation.
We don't want this bill to pass until he come back and we co-design it.
We've given him the opportunity today to do that and to pause this bill and at least talk with our cultural elders behind me from all over the state.
The bill is not fit for purpose. It does need to be co-designed with Indigenous leadership. What we saw was consultation. We want to make it very clear that consultation does not mean consent, and we need a formal process for negotiation so that we can get on board, do this right, and look at how we protect Aboriginal cultural heritage for the world.
Thanks, Emma. That just about concludes what I wanted to say today. There's one more, there's one more slide there. The events of Juukan Gorge were terrible, but if they've had one positive purpose, it's actually been to enliven, possibly for the first time, big institutional shareholders and ordinary Australians to just how this great wealth that we all enjoy is being made and where these dividends are coming from. Nobody's talking, I mean, in fact, most of those people, many of whom I know that we just heard from, are not anti-mining. They're just looking for respect and the sort of say that you might expect would be someone who is the owner of the land and the custodian for thousands of years would be entitled to. Another one of the benefits of the Juukan Gorge cave engagement of last year is that after some years of not working with Marcia Langton, a very eminent Melbourne-based academic from Queensland originally, Marcia has accepted ACCR's invitation to join our research committee, which I feel very excited about. This gives us more capacity to think more carefully and more deeply about where we might reach next in this line of work. And finally, I hope that we can continue this work and to continue to develop this relationship, to keep building this bridge between investors and the people most affected by many of the industrial activities undertaken by ASX-listed companies, especially mining companies. But that's all I wanted to say to you now. I hope I haven't gone too long, Emma.
Thank you, James, for that fascinating presentation. I know we'll continue to look forward to the work you'll do with First Nations partners. And Jeff actually just had a question come in. Oh, no, it's not a question, but it's a very nice comment.
Thanks, Joan. Joan's an old colleague from Cape York. Thank you very much, Joan.
Oh, it's lovely. Well, if anyone has any questions, now is the time to ask them. Or if you're not comfortable asking, you can always email us and we'll pass them on to James after this webinar. But if there are no questions, it's now time to say goodnight to James. Thank you so much again for presenting tonight. And like I said, if anyone has any more questions, feel free to forward them to us and we can forward them to James after this as well. Thanks again, James.
Thanks, Vanessa, and thanks everyone for listening. Enjoy the rest of the presentation.
Thank you. Have another thank you. And if there's no questions for now, so I think I'll pass on to Emma to get started on the shareholder advocacy part of this webinar.
Thank you, Vanessa. Hello, everybody. Thank you for staying around. And just to reiterate what Vanessa said before, that if you are an existing shareholder or you know the specifics of this work, please feel free to jump off as well. If not, stick around and I will tell you some more about it. And I am joining you from Ngunnawal country today as well. So I'd like to acknowledge the traditional owners of the land that I'm speaking to you from as well. Now, what I'm going to go through tonight is a bit about the basics of share ownership and the different ways that you might hold shares and how that will impact the way that you might participate in our work. I'll go through a little bit about the process of registering your shares with us and the agency agreement that you enter into with us when you do that, what that means and what it does. And I'll talk a little bit about the process of participating in a resolution and what that would look like for you as a shareholder. And then we can talk about other ways you might like to be a part of our work if you don't hold shares. So feel free to pop in any questions as we go along. Vanessa can call them out to me and I'll try and address them as I'm going. Otherwise, we'll have time at the end as well. And because we let James go over time because he was so interesting and engaging, so I'll try and be a little bit speedy so that we finish at the right time as well. So as James has mentioned, being a shareholder in a company translates to ownership of that company, and with that ownership comes a number of different rights that you're able to make use of. Shareholders don't assume everyday responsibility for the management of a company. So the kind of, very day-to-day processes of a company, that's not something you're able to have a say on or an influence on. But you can influence company behavior over the longer term and on kind of broader picture things. So the way you can do that is through board composition. At a company's annual general meeting, shareholders have the opportunity to vote for directors they would like to see on the board or vote against them if they don't want to see them there. You can vote for amendments to the company's constitution. And these can be all different things, but also that in particular is one of the ways that we're able to put a shareholder resolution to a board. You can have a say on the company's finances and transactions through being able to vote or ask questions about their financial report. And you can have a say on environmental and social issues. And a big way we do that is through the putting of shareholder resolutions to companies on those issues. So an important thing to take away is that shareholders of different sizes will have different options to exercise these rights. So say, a super fund that holds millions, billions of dollars of shares in the company has very different sway and access to a company board than, say, a shareholder like me, who is just an individual that holds a small parcel of shares in that company. Generally, the bigger your holding, the more access you have. You might be able to have, say, a one-on-one meeting with a company director or the board. But if you're a small shareholder, really the only access you have to the board is that one day a year at the company annual general meeting through exercising your proxy vote, or, as we'll talk about, in coming together with other shareholders to be able to put a resolution to a meeting. So I just wanted to talk about also, I forgot I put this here, the idea of divestment versus engagement. And really, you can only make use of the tools that I just talked about if you are a shareholder. And there are a lot of people who are shareholders that aren't necessarily engaged. So with that ownership and that access, you have the option to engage with the company. And again, that might vary depending on the size of your shareholding. You can participate in or vote on shareholder resolutions. You can vote on anything using your proxy vote at a company. You can attend a meeting and ask questions of the board in person, or at the moment virtually. Sometimes a company might have an extraordinary general meeting for a special matter, and shareholders can come together to call one of those or participate in one if one happens. And then another tool you have is to divest. So the divestment movement is growing, and there's a lot of organizations such as our friends at Future Super who are, I guess, a divestment focused fund, and they're more defined by what they don't invest in than what they do. And what we're seeing, and I guess what I want to point out to people, is that divestment should be considered, in our view, at least at ACCR, as kind of the last option in your toolkit. So once you've exhausted all of the other options in the scope that you are able to, and if you're not able to see change that you'd like to see at a company, or the company still isn't able to align with your values and you don't feel comfortable having your money there, then of course you're free to divest. But what we're seeing with a lot of our peers and a lot of other, I guess, ethically minded investors is this idea of being able to divest, if that's your choice, but maintaining a small position in the company, so a small number of shares that still allow you to make use of those other options. And certainly when it comes to shareholder resolutions, it's a smaller holding and acting in cohort with other shareholders actually opens up a much larger amount of power than if you were to act alone. So to be able to make use of those powers, it really depends on the way that you hold your shares. So there's, broadly speaking, two types of share ownership, direct and indirect. In a direct ownership model, you are the legal and beneficial owner of those shares. So there's some examples there. I could be Jane Smith owning my shares in my own name, or I might be Jane Smith, who's the director of the Smith family company, or I could be the director of a family foundation. And then that foundation or that company is the owner of some shares. So you have direct control over those shares. You have the option to vote them, and then you also benefit from them financially. Another model of share ownership is indirect ownership. And what this means is that you are not the legal owner of the shares, but you're the beneficial owner of the shares. So you benefit from them financially, but you don't have any of the power to say what shares are bought or how they might be voted. So an example that you might be familiar with is your superannuation. So I am a member of Future Super, and in that arrangement, they manage shares for me, as part of their investment strategy for my superannuation, but I can't direct them in any way as to what companies they might hold, or if they were to vote their shares on any particular issue, how they should vote them. I just receive the financial benefit of those shares. So unfortunately, for people who are exposed to shares through indirect ownership, you're not able to participate in shareholder resolutions. But for those of you who might own your shares directly, you can. If you're not sure, a lot of people who we speak to aren't entirely sure how they might hold their shares. So if you're ever not sure, a good way to know is if you receive any proxy voting forms at that time of year. If you do, that's a really good sign that you hold your shares directly. Another way to tell is just by the way the name of the shares looks. If you aren't sure, just send us an email and we can absolutely help you out. And if you do hold them directly, then we can have you involved in resolutions. So to be able to lodge a shareholder resolution in Australia, we need 100 shareholders in a company to come together, and that's the minimum. So what Vanessa and I do here at ACCR is we look for those hundreds of shareholders and kind of coordinate them all in order to put a particular resolution. So at ACCR this year, we filed, I think it's 11 different shareholder resolutions to 11 different companies this year. So we were looking for over 100 shareholders in each of those companies throughout the year. So it's quite a difficult job at times, particularly finding shareholders in a particular company, but we're always looking for shareholders in any company because, like we've only just heard from James about particular companies of focus for that area of work, but across our other work streams, which are climate and human rights and workers' rights, there's a whole breadth of companies that we engage with and might file resolutions to. So we're looking for shareholders in many ASX-listed companies. And the task that Vanessa and I have is finding that intersection of people who care and are interested about the issues that we're interested in and that we're conducting research in, and then who also own shares or have capacity to own shares in listed companies. So it's actually quite a small segment of that Venn diagram of people that we're trying to connect with. And hopefully that's some of you here tonight. Before I go onto the Shareholder Hub and show you some of the details of participating, we have this lovely cartoon that was drawn by one of our shareholders. Her name is Holly, and she's an illustrator and graphic designer, but she also has a portfolio of shares that she has listed with us to participate in resolutions. So this is something she put together with us that explains our work from the perspective of a shareholder. So in this example, we have a couple and they work with a financial advisor. They need the money that they make off the shares. They're relying on that for income, but they also, want to invest in a way that aligns with their values and supports, the people and the planet. So their financial advisor suggests to them that they look at us, ACCR, and perhaps that could be a way that they could do that. So once you register your shareholdings with us, we, in the background at ACCR, we have 20-something people working with us now across our research and advocacy and operations. We conduct research, we engage with companies, we engage with affected community, and then we're also supporting shareholders in registering and participating in that work. So once we've filed a resolution, we have that 100 shareholders, we've done all the paperwork, and we've filed the resolution. When it appears on the notice of meeting, all the shareholders in the company have the opportunity to consider that resolution, and we'll speak to it at a company's annual general meeting as well. And sometimes people may give their proxy for members of the affected community to attend, as James described, to have that direct access to the board. And then once the resolution has happened, we let you know what the results are and what the impact has been, and then what will be the next steps, because I don't think it's ever been the case that one resolution is enough to create lasting change. It's coming back year on year and pushing companies incrementally over time. So it's often a longer term engagement that you might be involved with us. And then once that's happened, we let you know the good news. So really, it's quite light touch as a shareholder. We do all the heavy lifting, but we absolutely could not do it without the shareholders who come together to get that resolution up. So let me take you to the Shareholder Hub.
While we're just going to the hub, Emma,
yes.
I've got a question about whether we solicit interested people to buy positions in our target companies.
Indeed. So what we're looking for predominantly is people who own shares in companies, and that's the sorts of people that we're connecting with. But absolutely, we find for a lot of the people we talk to that they might have shares in super, but not hold them directly. And because of that, they're not able to access this power. So they might buy a parcel of shares specifically to be able to participate. So that's certainly the case that we have people who do that. We have other people who might have, say, an ethical fund where they've screened a lot of the companies that we're interested in. And then what they'll do is buy a small parcel of shares to be able to access this power again. So while we aren't able to give financial advice and purchasing shares might not be right for you or your situation, we certainly do have people who work with us for whom purchasing a parcel of shares to participate in this work is right. And certainly if that's you, we would be very happy to speak with you and let you know what companies are coming up where you could have the most impact. All right.
Also,
yes.
Just another question. It's, how are we funded?
Yes. So we're a not-for-profit organisation and we're philanthropically funded. Our research fund has DGR status, so people are able to give tax-deductible donations to us through that fund. We're predominantly funded by philanthropic organisations, some family trusts and foundations, individual donors. It's a breadth of people. Actually, I'll show you. We can put this in the link to our follow-up email tomorrow.
Yeah. We can definitely send me.
Yes,
And I think some of it's in our annual review.
It is. It's in our annual review, which we'll send it. Sorry, I thought the link was down here, but it might. Oh, I think it's on the about page. Yeah. Yes, we have a list of some of our funders. So that information's available on our website, and we'll also pop the link to it in our follow-up with you tomorrow as well. Okay. And another thing I should say is we absolutely do not receive funding from any ASX-listed company, because that would be very contradictory to the work that we do. So this is our Shareholder Hub. You can find it here on the ACCR website. It's over here in purple. I feel like I've been saying this for a while, but we are making improvements and adding more content to it over time. Something that we're working on at the moment is a new sign-up form for people to register their shares with us. So something that will make it really easy for you to register shares, to update your information and keep in touch with us. So that is a work in progress. But I'll show you our temporary form at the moment, and I'll just talk you through some of the information that's required. So if you come to the hub and you come to this form, The questions that we ask you and the information that we need is the minimum information about your shareholding that allows us to validate that you are a shareholder. And when we file a shareholder resolution with a company, it's what allows the company to verify that you're a shareholder as well. So we keep this information safe and secure in our database. And none of this information is ever publicly disclosed or available. The only people who see it is us and then the company when we're filing a resolution. We don't ask for anything financially sensitive. So we ask for the name that you hold your shares in. And if you remember that slide before, that it might be in your name or your super fund's name or a company's name. We ask the address that's associated with that holding. And then we ask for the last 3 digits of your HIN, which I think is on the next slide. Let's do me as an example. There I
am. Just while you're typing that, I'll just also add that when you do participate in resolutions, that knowledge isn't publicly available to anybody. So it's not, you're not going to be known. It's still private. So if anyone's ever concerned that participating in a resolution means you're part of any public list, that's not the case. And really, the only people who know about it is us in the company.
Yeah, absolutely. And before I go to the next slide, this part here, how did you find out about us? That's really helpful if you don't mind letting us know, because Vanessa and I are testing different things all the time to see where we might be able to find shareholders and people interested in our work. So if you let us know, that lets us know something we're doing well and that we can keep trying. So if you pop that in and hit next. So we ask for, as I said, the entity name, the address associated with it. Now, the last 3 digits of your HIN or SRN, that's your shareholder identification number. And we don't ask for the full number because that is quite financially sensitive, just the last 3 digits. And we do that because some people may hold shares in the same name and have the same address, but have different HINs. And so that doesn't happen often, but it can sometimes, where each company you own might have a different HIN or SRN. And so that just helps us kind of keep track of all your different holdings and keep them up to date. So please don't give us the full one. That's for you to know and not for us. And then if you can let us know what companies you hold in the new form, this will be much simpler. So I apologize for the temporary form. Here we have a list of companies that we typically look at. And then if you have anything outside of that, you're very welcome to let us know what that is, because depending on issues, time, the number of companies and the different companies we engage with might change. So it's always helpful for us to know how many people we have in any particular company at any time. And then if you have other shares in a different name or with a different HIN, you can just say yes and fill them in as well. So it's quite a simple form. It won't take too long. It will be better, I promise. So once you've filled that in, your information is stored securely in our database. And if a company that we're planning on putting a resolution to, if you hold that company, so we can use an example of Fortescue Metals that James just mentioned, we will get in touch with everyone who is registered with us that holds Fortescue Metals and then let you know about that resolution. And you have the opportunity to opt out if it's not right for you. So don't feel that registering your shares with us means you'll automatically be participating in all of our resolutions. You'll still always have the opportunity to opt out of any particular one if it doesn't feel right for you at the time. And we do have people do that sometimes. And once we've let you know, you'll have a window to opt out. And then we will, once we have our pool of shareholders, if we need to find a few more, we'll do that. And then we double check everyone's information at the share registry. So if it turns out that you've told us a name that's a bit different or address that's a bit different, or you thought you held the shares, but it turns out you don't, we'll get back in touch with you and just clarify that before we file the resolution. And then once we've filed and the resolution's been accepted by the company, we let all the shareholders know. And then once the AGM takes place, we'll let you know the results and what happened and what might happen next. So what allows us to do all that on your behalf is the agency agreement. And what it is a weak power of attorney. It just gives us permission to essentially do what I said, which is prepare the paperwork that we have to give to the company to say that you are a shareholder in this company and that you have given us permission to participate in this particular resolution. So the full terms are here, they're on our website, and you can look at them at any time, but basically it's just talking about the relevant corpse law that allows us, Corporation Act law that allows us to file that resolution. I think, have I done everything I said I would? I'm conscious that it's it's 7 o'clock. If being a shareholder isn't something, if you aren't one, or it's not something you feel is right for you or part of your financial situation, as I said, we have a research fund that has tax deductible status, and you're very welcome to make a donation to us. It's also immensely helpful to us to let other people in your life who might own shares know about our work as well. And you're very welcome to follow us on social media to share any of our content if that feels right for you, because we are always looking for more shareholders. Vanessa, any other questions?
Emma. And I do apologise for my audio issues. I am not sure what's been happening with my headphones today, so I'll try and keep my talking to a minimum. But it looks like we have no more questions, Emma.
Wonderful.
Oh, actually, sorry, one of them has just come in. Would you consider creating how to vote guides for AGM so that we know how to vote on resolutions apart from the ones you propose? That is, for example, voting for directors with better ESG records.
Yes. This is funny because I've been talking to somebody about this just today. So what that is essentially, I guess it's called proxy advice. So all the large investors that I talked about previously, like super funds, and they're called institutional investors, will get proxy advice from those businesses. That's pure job, is to give proxy advice, because people may hold so many shares that they just can't possibly sit down and make an informed decision about them all. So they rely on proxy houses to provide that advice. Lots of the time people will vote in line with that advice, and other times people will still make their own decision about how they might vote. And actually an important part of our work is, once a resolution is on the notice of meeting, that we engage with proxy advisors to let them know about the resolution and how they should direct people they advise how to vote. And then we engage with investors as well, because of course they may not vote in line with their proxy advice. They may make their own decision. So at ACCR, we don't really have the capacity to be offering proxy advice as well. What we do, what we're trying to work towards is to develop a voting policy where we can publicly say this is how we vote, and other people may choose to vote in line with that. But I guess at a minimum, many of our shareholders who will participate in putting a resolution on the notice of meeting will vote in favour of that resolution. And generally, we find they vote in favour for all ESG resolutions that are put forward. So other organisations such as Market Forces or the Kolong Wilderness Foundation have also been putting shareholder resolutions to companies that they'll vote in favour of them. In terms of directors that is a lot of work because there's so many directors, and we really have to research kind of all of the other boards or committees that they might sit on, what their outside interests, such as I guess a big one is for climate, for people who are, I guess, quite climate denialist in their personal lives, and how that might influence them as a board member at a particular company. So it's a big job, and it's not one that we've had capacity to do before, but it is something we're very aware of and very conscious of, and something we would like to do. So I can't give quite a satisfactory answer at the moment, but it's definitely something that's on our radar.
Thanks for that question. And thank you everyone for coming again tonight. It's now 7:05. So I think we'll say goodnight here. And if you have any more questions, please send us that email on the screen. Send them to us on that email. And if there's no more questions, I think we'll end it here, Emma. And yeah, have a good night, everyone. And thank you again so much for coming.
Yes, thank you. Thank you for coming. We really appreciate it. And definitely, if you have any follow-up questions, feel free to get in touch. And for James as well, we're very happy to pass them on. Excellent. Thank you for staying a little late.
Thanks. I tried to research his affiliations performance industry. Yeah. Thank you. All right. Thanks, everyone. Good night.
Thank you. Good night.